especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
This is the next search on February 28, 2020, 7:44 p.m. How, period, does the FBI find people? The people's misspelled P-E-O-O-P-L-E.
I object.
Did the defendant find out how the FBI finds people in this case? Oh, she found out.
What more do you need to see?
All right, welcome back to the Court of Public Opinion. I am the Recovery Addict. I'm now thoroughly medicated. Took an antihistamine. I think. I'm not sure exactly what I took. It was an allergy on it. Whatever it was, I took one of the allergy ones, and I have a mug, which was a gift to me, by the way. Shout out to Sergeant Ranch Lodge in Pierre, South Dakota. Thank you. It's full of Stevens hot cocoa, and it's piping hot. So I did not have a ham sandwich. I checked the fridge. There was nothing there. So took some allergy meds, drinking the hot chocolate. We're ready for part two of day 2, which is coming up here shortly. Have you made an ew gross soundbite yet? I have not, Sophie, and I should, because it was sent to me in a great format. I should have used it. I have not. I don't have an excuse, really. I'm sorry. That's all. All right. Oh, let's see. Early chat was wild this afternoon. I missed it. What was happening? I was on the phone with a friend. Sorry. Sophie, Hank Sandwich, thank you very much for the super chat. Welcome. I see a couple Hank Sandwich and ham sandwich things in there. See my message up there? Red? Let's see. What did you have? Did you tag me in it? Down, Clora? That one? She Googled sent Bunny it to... You've got a couple messages, Red. I'm looking. I guess the correct answer is no. No, I did not. I did. You've got a... Which message is it?
Hey.
You've got to see Red's ham sandwich factoid. I missed it. Let's see. Ham sandwich was good. Ate it too fast. Now finishing up with my spicy Snicker for a sidebar prep. I can't scroll up far enough. And I probably missed it again. In police slang, a ham sandwich refers to an untainted pew-pew that a corrupt officer might have ready to plant on a suspect, often after the officer has shot them. Oh, my goodness. Straight out of the Urban Dictionary, ham sandwich is not what I thought it was. I thought it was actually a ham sandwich. My mistake? You can see where I went wrong. Wow. I don't think it's... I think that's pure coincidence. Pure coincidence. Chat not on screen. Fixed it. Thank you, Melissa, for that. Welcome, Greeners. Greeners first in chat this afternoon. Greeners, you've won before. You'll probably win again, honestly, if we're just being truthful amongst friends. But we're going to send you to internet ownership. You've done well the past times you've been punished, so we expect nothing but that this time as well. So, good work, all of you. Amber's mom is here. Everyone say hi to Amber's mom. K. Vixen mom is here. Had bologna instead of ham. Welcome.
I don't like podiums, Your Honor.
All right. If you have any complaints about Amber, now is the time to air them as well. Probably get most bang for the buck for your mileage. If you it's one thing to complain to Amber directly, but Amber's mom is here to have her ear. So I'm just saying. She's gonna quit if I do. Don't send hate mail to Amber or Amber's mom. We love Amber. Welcome. Good to have you both here. All right, Ernie Unflawless says I'm getting no chores done waiting for this cross. I know It is so spicy. It's like every day of court, they just turned the spicy meter up, and it's all the way. They cranked it, and now they're like hitting the button as well. It's awesome. Karen from is it Chatham? Is it Chatham or Chatham, Ontario? Welcome. Red says, oh, another one. I suggested why soundbite from the stream on day 29 of trial. Judge says, why? Clearly, and it's hilarious. I'm all set up to make these in the moment, and I really should do them. I'll have to research why. Sounds like Mr. Brennan is jealous the ARCA is working for the defense. I rescheduled my grocery trip for this. I canceled my dialysis to be here. What's the best this is my top priority excuse you can come up with? Nothing like it. Woohoo! Happy birthday, Kai! Thank you. Happy birthday, Kai. Dr. Rentschler's child, who has a birthday today. Member for 3 months. Nothing like it. Thank you very much. I mentioned it in the comments on that day's stream. Easy to find. Okay. I'll look. I canceled my wedding today. He can wait. I canceled my funeral. I was planning on dying today, but I had to delay it because that's so dark. I put off my heart transplant. My wife's still at the altar. I told her I'd be back after the conclusion of the live stream. Canceled my child's birth induction. Called in sick. I canceled all my memberships for this. Motion to sing happy birthday to Kai. Well, we can do it, but I'm stuffed up from the antihistamine. That's not how it's supposed to work. Let's do it. Let's sing happy birthday to Kai. We've already warmed up. Well, let's do it one more time. Ready? La 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 la. There we go. All right. Let's sing happy birthday to Kai really quickly. I hope this gets to you, Kai. Happy birthday to you. Happy birthday to you. Happy birthday, dear Kai. Happy birthday to you. Happy birthday. And for your birthday, we got happy birthday, Kai, trending somewhere on Twitter. So happy birthday. It's awesome. Your dad gave you a shout out in court. It's on the record. It's in the record. Like when they read the official transcript, it's going to say from your dad, happy birthday, Kai. It's like it's almost engraven in stone now. That is just really cool. Happy birthday. Have a good one. All right. Your dad's the best. Happy birthday. Then it was objected to. Yes, there is an asterisk next to it, sadly, that it's like objection sustained. But happy birthday is in there. You can read it. It's clear. All right. Only paid my electric and Wi-Fi bill this month. Who has time to shower during this trial? Says Jackie. Kai is 10 years old today. 10 years. That's an awesome. You went double digits. You don't get another digit for like another 90 years. That's huge. That's huge. Awesome. Let's see. Need to drink more water. Allergy prescriptions make you. I've had like. This is my 5th bottle today. So what's 5 times whatever the many this is? 16.9 fluid ounces. I'm practically a fish at this point. There's a risk of me drowning before I get dehydrated. But yeah, good stuff. All right. Plus, I have all my hot chocolate as well, which has water in it. So it's like
I'm not going to argue about semantics here.
Yeah, drowning on the live stream. It would be terrible. That better not be the purple drink. Oh, no. The one I had, obviously, I'm not going to take drugs that make me loopy and then go live stream because you know how bad that could be. That would live forever. Imagine me with no filter and saying weird things that pop into my head when I'm a little bit out of it. That would be Les Bad Cinema. Les Bad
Somebody
Cinema.
just sent me a video of roaches fighting. I don't know who won.
I don't know who won. All right, Pantoufle. Brennan's bring this birthday bias in for trial 3. Too many B's. The alliteration tripped me up a little bit. Veritas is like, why not? Do it. Do it. It would be a blast. It would live forever online. That's for sure. There would be all sorts of clips made, and I'd probably get banned. Can we have a poll on how to make your hot chocolate with milk or water? Lindsay, I do it with water because that's what Steven's Gourmet Hot Cocoa recommends. But I did make mine a little special because I ran out of milk chocolate. Don't tell Mrs. Ari. I used all of her milk chocolate, Steven's Gourmet milk chocolate mix. She doesn't know. She does not know yet. I used all of that, and then I used a spoonful of her Steven's Gourmet hot chocolate candy cane mix, and I thought, I don't want too much candy cane in there. But then I found she had one more container of Steven's Gourmet hot chocolate, no sugar added mix, which is basically like cocoa. And so I added a spoonful of that as well. But it's all in here. It's basically straight sugar, minus that one scoop. Okay, Steven's is the best. I love it. Although now I owe her some more hot chocolate. I did. You guys promised not to tell her, right? I put the empty can back up with like half a spoonful in it. Is that the wrong thing to do? If she finds the can empty in the garbage when she comes home, she's like, hey, you ate all the hot chocolate. But I put it up there so now someone else will be like, oh, I was making hot chocolate and we're out because there's a little bit left, right? It's not all the way gone. It's very wrong. All right. I'll have to fix it. 1/2 a scoop is not enough to make hot chocolate. It isn't. You shouldn't make hot chocolate in amounts that small. It's less than the serving size. Just put a scoop of the no sugar in the normal container. Oh, Ivan, I like the way you think. Maybe that will save me. Yeah.
You are unmuted.
We're unmuted. Here we go. Guys, buckle up. It's gonna get spicy this afternoon. Sandy gifted 10 memberships. Thank you, Sandy. Congratulations to the winners.
Now open to be seated.
All right, while the jury is on their way in, I need to see counsel at sidebar.
Sidebar number 8. Number 8. We are rapidly approaching the level of sidebars we have when we have no sidebar days. They are building up quite rapidly. This one called by the judge, and she's not shy about that. Oh, let's look at the OnlyFans. This cameraman gives us a lot of courtroom feeds during the sidebars, which is okay. They're not focused very well, but we'll take what we can get. Val says, I just got a new membership. Thank you, Wendy. Thank you. Have a new person. Sit next to Peggy. A friend. Victim advocate. Oh, you must try this Costco find. What is it? Perk. Here comes the jury. Number 8 was the shortest sidebar of the day. I don't do coffee though. Looks like tan mocha latte. Just do hot chocolate. It's not coffee. But it tastes like it. I don't do like candy that tastes like coffee. It doesn't appeal to me.
We seated. This court is in session.
All right. Mr. Brennan.
Here we go.
Jurors, hopefully it'll be comfortable enough in here this afternoon. The court officers has done a great job keeping the AC going while we were out of the courtroom. So.
Like that was hard work. It's like, don't flip that off, please. Karen Reed did ask for the fan speed to be turned
Dr.
down. Dr.
Rentschler,
right on her.
You wrote a report back in February 2024?
That's correct, yes, sir.
And in that report, you provided a number of opinions, didn't you?
I did, yes.
Do you remember if you opined or had the opinion that the injuries on Mr. O'Keefe's arm would not result from impact with a non-damaged tail lamp cover?
I believe that's correct, yes.
And the amount of force required to fracture the tail lamp cover would result in extensive soft tissue and likely bony injury to Mr. O'Keefe's right arm.
Correct.
And so your opinion back in 2004 was that if a person's arm were to cause the damage to that taillight on that Lexus, you would expect to see extensive soft tissue and likely bony injury.
Yes, soft tissue referring to ligaments and tendons of the elbow and shoulder, correct, and the wrist.
And so you're saying not superficial abrasions, but in the arm?
Yes, when you look at, and from you can see from the testing we did for this case, for this round, that the arm extends and you have contact with the arm, you would expect at those speeds damage to the tendons and the ligaments, the elbow, the shoulder, likely the wrist.
In the x-rays that we looked at, or that we saw, and you offered the words of the medical expert, there is no MRI studying any ligament damage, is there?
There are no MRIs that I'm aware of, no, sir.
And x-rays wouldn't fairly depict some of those internal injuries that you're referring to, would they?
As I described before, it can show laxity of the joint, but it normally doesn't show the actual soft tissue damage itself, no, sir.
And a crash test dummy is different than a person, isn't it?
Certainly it is, yes,
No
sir.
muscle.
In most
That's
cases.
correct.
No ligaments.
That's correct.
The crash test dummy does not react or respond like a human being.
Well, it does to a certain extent, yes.
There are differences.
Certainly there are, yes.
And so when you're looking at a crash test dummy, you can agree that there are significant differences between what you might see on the dummy's arm and what would maybe happen to a human being's arm on the inside.
There can be. That's why you have to look at the acceleration and the force, and that's primarily what the ATD is utilized for.
But focusing on the actual observation of the arm, you would agree, doctor, that looking at a crash test dummy arm is not comparable to actually looking into a human being's arm with an MRI and seeing if there's any damage on the inside.
No, of course, that they're not the same, no, sir.
You were speaking about references earlier. You did have a chance to see Dr. Welcher's report, didn't you?
I did, yes.
And in his report, there were a number of references, weren't there?
There were different references, but I think maybe 26 within his report.
In addition to his references, you were sent a number of gigabytes of information, weren't you?
I was, yes.
And in those gigabytes, there was different references to different materials, wasn't there?
Well, first of all, there were only 26 references in his report that he cited to for his opinions. There was material contained within the batch of documents that they sent over. There was a bibliography or CV of different papers that he had submitted, I think 20 pages of papers that weren't referenced in the original report. And the most recent paper in that AutoPed packet was from 2004. Most of them were from the 60s and 70s, but there was an additional packet of information.
When you read his report and saw his references, did you look up the references?
I did, yes, sir.
Okay. And when you were saying earlier that there was only one reference, you were referring to the paint test, correct?
Well, I was referring to there's only one reference specifically with respect to automobile pedestrian impacts.
When you looked at his references, sir, did you have an opportunity to read any of the articles?
I did, yes, sir.
And many of them are peer-reviewed?
Yes, sir.
In addition, when you looked at the 20 pages of materials he sent over that were not in his report, how many references did you read out of those 20 pages of references that he offered?
Well, I didn't read any because they weren't referred to in his report for his actual opinions in this case.
Do you know whether or not he considered those references or whether he read those references?
I'm going to allow that.
He didn't cite to any of those references in either the PowerPoint presentation or in his report. That's the knowledge I have of whether he reviewed those.
So you don't know what he considered or thought, do you?
I know what he cited to and he referenced to in his report in PowerPoint. That's the extent.
The question is, you don't know what he was referring or reading or relying on other than what was in his report cited, correct?
Well, right. If he referred to the other articles, yes, certainly other articles in the 60s, 70s, and 80s he may have, but they don't really pertain to what happened in this case.
How many references were in your May 7th report?
Well, I think there were... Let's see. Uh, 26, I think.
Those 26 references, are they offered in your report to suggest some type of support for the proposition that you're promoting in the report?
Well, they support the opinions or the methodology or both with respect to what I've offered in this
The
matter.
reason why you put a cite in is suggesting that it supports whatever proposition you're footnoting on that.
To some extent, or the methodology or some information pertinent to that opinion, yes, sir.
Regarding crash test dummies and prediction in soft tissue injury, you provided 3 sites, didn't you?
And soft tissue injuries?
Yes.
Can you show me where it says that, sir?
Footnote 11 of your report, Mr. O'Keefe's right arm kinematics during impact with the Lexus are inconsistent with producing the documented cuts damage to his right sleeve as well as the abrasions to his right arm. Did you write that?
Yes, and which one was that again? I just want to make sure. What was the number?
You cited footnotes 24, 25, and 26.
Yes.
And when you cited 24, 25, 26, did any of those 3 sites, in fact, those are the only sites that you cited for that proposition, correct?
Yes, sir.
So your entire basis of sites is limited to those 3 articles or 3 papers, yes?
For reference, it's not, the testing obviously proves differently, but yes, for that one comment there, those were the 3 that were provided, yes.
Starting with number 24. When you looked at 24, did it ever suggest, this paper, did it ever suggest that it was appropriate to use a crash test dummy in the material of a crash test dummy to make an analysis or determine whether or not there would be documented damage to someone's skin?
No, it didn't, and that's not what I did in this matter.
In this article you cite supporting the claim that you made, there is nothing in here that would suggest that a crash test dummy is appropriate to use in making that determination, is there?
There is not, no, sir.
In fact, in this article, it gives you details on what actually should be used to make that analysis, doesn't it?
No, sir. It looks at, it tells you certain ways to look at sharpness and how lacerations are caused.
This is titled Skin Tissue Cuttability and its Relation to Lacerations Severity Indices. You know that. You cited that.
That's correct. And it looks at specifically, I think, laminated glass and its ability to cut the skin.
Number 24 in your site, correct?
Yes.
And it tells you 3 types of skin were examined and used for this type of study. Post-mortem human skin from 2 different body sites, Cameos leather, and Napa goat skin. Is that correct?
Right, to look specifically at laminated glass and it's the cuttability of that type of glass.
And the reason why the study is giving those suggestions is because a crash test dummy's arm and fabric, the way it's made, is different than how real skin would respond. Yes?
Well, it is different, sure.
Yeah.
And I didn't do that type of comparison.
You did not do any comparisons with any of the suggestions in the site that you cited in support for your proposition, did you?
Oh, I did not evaluate that. No, not in that manner. No, sir.
And then you cited number 24 or 25. You cited a book, Forensic Pathology, correct?
Correct.
And in this forensic pathology book, in the entire book, it never suggests that crash test dummies are appropriate to use when making this type of analysis, does it?
Correct, and that's why I would not do that type of analysis with respect to lacerations. That's not what my analysis involves, sir.
My question was, nowhere in that book does it say that crash test dummies are appropriate for analyzing skin lacerations on a collision, does it?
Sure, I mean, for that sake, it doesn't say it's inappropriate either.
And then you also cited an article, your third article, Understanding the Acute Skin Injury Mechanisms Caused by Player Surface Contact During Soccer. Did you cite that?
I did, yes.
And again, there's nothing in there that talks about the use, the appropriate use of a crash test dummy when you are trying to support the proposition that someone's arm is consistent or inconsistent with producing cuts and damage in a collision.
That's correct.
Are you aware of literature relative specifically to the use of the Hybrid 3 crash test dummy, which was used in this case?
There's a lot of literature with respect to the hybrid dummy, yes.
Have you ever heard of the person by the name of Stanley Bakatis?
I don't recall that I have.
Okay. How about Harold Mertz? Isn't he a leader in the field with crash test dummies?
He is, yes.
Right. Would you agree that we also do not believe the current instrumented arm configuration is suitable either for prediction of soft tissue injuries? Would you agree with that?
Well, for laceration, sure, it shouldn't be used for that. It shouldn't be used in that manner. That's why I don't use it in that manner.
Do you have any source that says it's suitable for determining superficial abrasions?
I do not, no, sir.
You have no other sites whatsoever supporting that proposition, which led inevitably to one of the opinions you gave to this jury, true?
No, not true. That's a misrepresentation of what I performed, the testing that I performed, and the results that I analyzed in this case.
Now, you've talked a lot about Dr. Welcher's pain test. You don't have any information that Dr. Welcher ever claimed that his test was intended to represent exactly how Mr. O'Keefe's arm was when he was hit, do you?
Well, the evidence I have for that is that in his report he says that the orientation and position of the lacerations are consistent with the orientation position of the taillight cover, and then right under that he has reference to that test that he performed. So again, if he didn't intend to do that, then there's no evidence that he can provide with respect to the arm impact at all. That's the only test that was performed to look at the arm and the taillight cover. If it doesn't represent the actual position, then apparently he has no idea how the arm was positioned or how it was impacted.
Let's get back to my question.
Yes.
Is there anything where Dr. Welcher has informed you or written that he is intending to represent the actual arm angle of John O'Keefe when he was hit by Alexis?
Again, I just described what he has in his actual report. So he didn't write specifically that that's what it's intended to do. It seems he's inferred that, and again, that's the only test that he's performed or referred to in this case.
You inferred that?
Inferred that that's how he believes that the arm was positioned?
I think we understand your perspective is that the only test he performed, but what I really want to get at is your conclusion, your assumption that Dr. Welcher was suggesting that there was a specific arm angle that occurred in this case that he was identifying. You don't see that anywhere in his report.
Well, it would be pretty odd if the one test he ran didn't actually represent what he thought happened. I don't understand what the value of that would actually be.
Did Dr. Welcher ever represent that he was trying to describe the actual body position?
Yes,
John O'Keefe when he was hit?
In the photo, side by side.
Actually,
with the
he
image
doesn't
blown
state
up.
that. He states very little in his report or in his PowerPoint. He demonstrates through the video of his arm like that and contacting it, and then he holds his arm up to a picture of Mr. O'Keefe's right arm to compare and apparently demonstrate that it's in the same area. But again, he doesn't actually state that opinion. He doesn't state any opinions that the contact actually occurred, except in one point, and has no evidence or foundation for that.
Would the answer to my question be no?
You would have to ask Dr. Welcher, I suppose, but if it's not, again, then I'm not sure what that test actually accomplished or represented.
you've made assumptions and then have given opinions to this jury based on your assumptions, haven't you?
I've evaluated the evidence in the one test he ran. If that's incorrect, well, then I would have to correct my opinion and my assumption and say that not only is the test not actually show what occurred, but he hasn't performed anything to actually link the arm contact to the taillight cover. If it doesn't represent that, you're right, I'd change my opinion that there's no evidence, no analysis, no conclusion whatsoever.
I'm going to try to make my question a little clearer.
Hank's losing every time he asks this.
Anything in the report where Dr. Welcher has stated that the arm angle in the demonstration was in any way attempt to replicate exactly how John O'Keefe's arm was when he was struck by Alexis?
I don't believe anything's written in the report with respect to that, no.
Is there anything in the report, Dr. Welcher, anything, that states Dr. Welcher was stating or claiming that he knew the body position of John O'Keefe when he was struck?
Objection.
I'm going to allow that.
So no, I guess there is no opinion or conclusion that he knows how Mr. O'Keefe was actually positioned at the time of this alleged incident. You're correct.
Do you know whether Dr. Welcher has been clear that he does not know? Let me say this a different way. You would agree Dr. Welcher has never stated in his report that he can identify the speed at which Mr. O'Keefe was struck in a collision.
He does not state what he thinks the speed is. That's correct.
He never states how far, if at all, Mr. O'Keefe was thrown after being in a collision.
That's right. He does not.
When you don't know the speed, you don't know the body position, and you don't know the angle of the body at the time of collision, you cannot replicate a collision with crash test dummies to a reasonable degree of scientific certainty.
Well, you're right. You can't prove that that actually occurred. That's the basis. Yeah.
So,
if you don't have the information, you can't replicate what happened. You can't determine, you can't state to any conclusion of accuracy what actually occurred if you don't have the evidence.
So if you were to do a crash reenactment, but couldn't state to a reasonable degree of scientific certainty this replicated the actual collision, that wouldn't be scientifically reliable to a reasonable degree of scientific certainty, would it?
Well, if you perform a test and you state this is what I tested and this is the angle, then you can certainly say these are my conclusions. But if you don't know the throw distance, if you don't know the position, then you're correct. You can't actually come to a conclusion that it didn't occur. If you don't know how something occurred, how can you conclude that it actually occurred? It scientifically makes no sense.
Brennan, sit down.
So, if an expert does a crash test and they can't determine to a reasonable degree of scientific certainty that it replicates the actual collision, you would agree that would not be a reliable test to present to a jury, don't you?
I'm going to... Very briefly.
Number 9. Is this number 9? Very briefly, sidebar. So now Mr. Brennan is trying to get a win out of this. Every time he goes back and tries to get his answer, the witness is just beating him over the head with it and saying, yeah, you there's no evidence at all. You're trying to get me to say that he didn't say what he knows happened. And he's like, apparently he doesn't know anything about this. And there's no evidence to support there was a collision if he doesn't have any of this. Now Mr. Brennan is trying to get him to say, if you didn't know all the facts of how it happened, then you shouldn't present that to the jury. I believe the response would be, it shouldn't be presented to the district attorney. All right. It's screaming goat time. It scientifically makes no sense. She was going to allow it. She's going to allow it. She said she would. She has promised Mr. Brennan that he gets to have a vigorous cross. What was the term? An in-depth, a robust, or I think robust was the word. Robust cross. And he's getting it over objection. Brennan is digging a hole. I predict that Brennan will get a win. He will get a concession. He will get the answer he's looking for eventually. But the number of losses he's taking to get to that point are mounting up. A thrustful cross. If you don't know what happened, you can't prove it. He's like, that's actually the whole premise of my opinion. A fulsome cross. Jen, you need to rewind. You do need to rewind. Just to lunchtime. That's it. Sidebar number 8 going down right now. Nine. Sorry. Thank you very much. Of course.
In reading the reports and evaluating the PowerPoint, would you agree there is no statement by Dr. Welcher ever in anything that you reviewed that he is claiming or stating that his pain test was supposed to be a reenactment, identifying the details of how Mr. O'Keefe was standing, moving, or holding his arm at the time of a collision?
He did not state that. That's correct.
So when you've made your criticisms that you've done testing regarding Dr. Welcher, you don't have any evidence, any statement by him that he was trying to reenact the actual collision?
When I did that, there's one test with the arm like this. That's the only evidence that was presented in his opinion or in his case. I evaluated that. I have not seen any other explanation of what happened or how it occurred. Specifically, Dr. Welcher said in his report on page 9, he said, I have conducted an accident reconstruction and biomechanical engineering analysis of this matter. If he did not recreate how he was positioned, if he did not determine the speed of impact, if he did not determine how Mr. O'Keefe's body moved, if he did not determine where he ended up, then he did not conduct either an accident reconstruction analysis or a biomechanical causation analysis. He did nothing of the sort.
Other than your opinion, let's get back to my question if I could.
I believe I answered at the beginning of that, sir.
I'm going to ask you again. My detailed question is, there is nothing in Dr. Welcher's report
that he's eating this
or
up.
any of his presentation that states he is trying to represent
I love him.
The exact posture, movement, and stance of Mr. O'Keefe when there was a collision. It's not anywhere in there where he stated that, is it?
It's not stated. I'd be curious to find out what that, if that wasn't the intent of the test, I'd be curious to see what the actual intent was.
Is the answer no, it's not in there?
I think I just said that at the beginning of my answer, sir.
I'm going to ask you again. Is the answer no?
The answer is no.
When you do crash tests,
he was so
you have
intent on getting his answer, he missed the no.
In some respects, don't you?
You do, yes, sir.
You get to control some or sometimes many of the variables, don't you?
You can, yes.
Real life sometimes is described in your world as chaos, right?
I suppose it could be under certain circumstances.
Testing is limited to the variables that you produce, but real life sometimes has variables you can't predict. Isn't that fair to say?
It's possible, yes.
Is it more than possible, Doctor?
I don't know, is it?
What? I'm asking you.
It depends on the situation and the certain variables. It depends on the case. It could be possible, yes.
Have you seen cases where the variables are impossible to predict?
Where the what?
Variables. Have you had cases? You've had many cases, you said. Have you had cases where variables are impossible to predict?
It depends. I mean, it depends on what you're looking at. And if you want to conclude that something happened and this is how it occurred, you have to look at those variables. If you can't control for those variables, then it's possible you can't prove that it actually happened. So yes, if you're doing a certain test to prove something, you have to look at how those variables may affect it. But there's basic information you have to know to perform that type of an analysis.
So my question again is, are there scenarios where variables are impossible to predict?
There could be, yes.
Have you had cases yourself where there are variables that were impossible to predict?
I suppose I probably have. I mean, it depends. If you don't know what happened, sure, then you don't know those variables necessarily.
How many cases have you done on pedestrian accidents?
Done hundreds of cases.
So you have a good background and basis to know whether or not there are variables that sometimes you can't predict, don't you?
Sure. As I said, it depends on the case.
When you did the crash tests in this case, did you actually do them?
I did not, no.
Were you even there when they happened?
I was not, no, sir.
So you're relying, in part, on Dr. Wolf's work?
I am, yes.
If Dr. Wolf made mistakes, would that affect your conclusions?
It depends what mistakes they are.
When you had, or when Dr. Wolf had the crash test dummy in test E and F on a forklift, do you remember those?
I do, yes.
When it's on the forklift, it does not allow the crash test dummy after being struck to move, to be thrown, does it?
Actually, if it's a force acting on it, it will move. It will like a pendulum. So if there's a force acting on it, you'll see which direction it moves. If there's a forward force, it will move. It'll swing forward or sideways or backwards. It can move.
Well, my question isn't direction. It's can it show the throw? Can it throw or move the crash test dummy in its natural course after the collision to a resting spot?
No. In those tests, though, there wouldn't be any throw.
If a crash test dummy is restrained by a forklift,
Mr. Brennan, that's the funeral procession coming through, but it's for you.
If a crash test dummy is restrained by a forklift, it does not allow the crash test dummy to be thrown, does it?
Assuming there is throw, that's correct. It doesn't.
It doesn't allow an observation of the crash test dummy to turn or fall, does it?
No, it does not. Well, no, actually it turns, sure. I mean, it can spin.
How about fall?
No. And a crash test dummy would just fall down anyway.
Have you seen crash test dummies where it is held in place electromagnetically, and when the collision happens, then the dummy can move? Have you seen that?
I have, yes.
Have you seen, excuse me, have you seen crash test with crash test dummy where there is a light? I'm sorry. Have you seen crash tests with crash test dummies where there is a light string and somebody cuts the string moments before the impact or a second before the impact?
I have, yes.
That wasn't done in this case, was it?
What? It wasn't. It wasn't necessary.
Was that done in this case?
It wasn't. I'll speak slower and a little clearer.
Maybe if you answer my question.
I just did answer it. I said it wasn't.
When the crash test dummy is held by a forklift and the car hits it, it doesn't replicate the drag that the car will have on the crash test dummy as it would a real person, does it?
You can see if there's any drag because it's on like a pendulum. So if there's any drag pushing it forward, it's going to sway that way. It's going to move the dummy. It's not going to move at the distance that it actually would. If there was any distance, it would move it. But you can actually see the motion. And you can see in the testing, the 24-mile-an-hour testing, there was no motion, which is not unexpected for that type of a test.
There is a difference between a crash on center of mass and a fender vault, isn't there?
There is, yes.
A fender vault is a different type of collision than a center of mass collision. Isn't that true?
That's correct.
It is impossible to replicate all of the different scenarios with a crash test dummy on a fender vault collision, isn't it?
I mean, it depends on what you're trying to replicate, and it depends looking at the injuries or how someone was positioned. So if you know how they were positioned, you can try and replicate that, yes.
Could I have 59 of Dr. Renschel's PowerPoint, please? In your PowerPoint, you cited an article, Vehicle Pedestrian Collisions, Validated Models for Pedestrian Impact and Projection, correct?
Yes.
And you put snippets up on the board?
Yes.
Okay. And these snippets talk about an engagement with the pedestrian in the vehicle?
Correct.
Okay. Is there a reason why you took out a piece of that article that falls between those two paragraphs?
I don't think so, no. Those were the most relevant parts.
Did you cut out the part that says some frontal collisions are with the corner of the vehicle where the pedestrian is deflected to one side without secondary impact of the upper body with the vehicle front? Alternatively, the transverse velocity of the pedestrian at impact may be sufficient to prevent head contact as the body rotates sideways off the bonnet, and these situations are known as fender vault. The models presented here do not apply to fender vault. Did you leave that part out purposely?
Oh, yeah, I did, sir, because this isn't a frontal impact with a sedan over the fender of the hood of a sedan. This is with the back of an SUV, so it's completely different.
You've cited many, many sources where it talks about front-end collisions, because that is the majority of pedestrian collisions, the front end, isn't it?
The majority,
Yes.
It is, yes, sir.
And so there is a difference between fender vault and a center of mass collision, isn't there?
That's correct, and that's why you see a center of mass. You look at the testing we did, that's the center of mass impact. On a frontal impact, usually, if you're hit by the front of a car, it doesn't usually get your center of mass. You're too tall. That's why you do a fender vault, or you flip onto the hood, or you flip over the top of the car. So, yeah, it's completely different. It doesn't pertain to allegedly what occurred in this case.
So let me get back to my question. When the tests were done, E and F, F was a center of mass collision at 29 miles per hour, wasn't it?
That's correct, yes.
Right. E, are you considering E a center of mass collision?
Which was E, the 24
miles per hour?
No, it didn't hit the center of mass of the dummy, it just hit the arm.
Exactly. So there is a difference. In this case, you don't know the position of Mr. O'Keefe's arm at impact, do you?
Nobody knows. I don't think his arm was even impacted by the car, so no. I don't know the position of the arm at impact because it wasn't hit by the car.
You don't know the angle of his body at impact, do you?
The alleged angle?
So ask the question again.
Okay. You have no information about the angle of Mr. O'Keefe's body at the time the defendant's Lexus was traveling backwards on January 29, 2022, do you?
We have no information that he was even hit by the Lexus. So there wouldn't be any information on the angle if his body wasn't hit.
When you talked about force equations with this jury, you cited a number of pieces of literature, didn't you?
I did, yes.
And when you cited the literature, you cited all literature regarding concentrated forces, didn't you?
No, that's not true.
There's a difference between concentrated and distributed force, isn't there?
Yeah, I talked about that on my direct, yes, sir.
When you showed your slides, for example, the hand.
Yes.
Could we see slide 8, please? Okay. Let's try slide 56. You would agree with me, Doctor, there's a difference between a concentrated and a distributed load, wouldn't you?
I would, yes.
When you gave your opinions in this case, it was based on concentrated load, wasn't it?
No, sir.
When you gave your force equations, was that distributed load or concentrated load?
Well, that was the load at the center of mass. And so you can evaluate that on a distributed load. You look at acceleration and you look at bending moment. So you can do both.
When you gave your charts and numbers, was that based on concentrated or distributed load?
No, that was based on the distributed load with respect to the center of mass of that arm and where the accelerometer was.
But this was not a center of mass impact.
We're assuming a center of mass is the most dispersed impact. So if we want concentrated, then we look at a focal point, and you can do that with the hand. But center of mass, acceleration, and distributed across the entire arm, that's where it's the least amount of pressure, if we're talking about force over area. And that's what I evaluated in this case.
When you gave your demonstration about the hand with the different hexagons on it, do you remember that?
I do, yes, sir.
Okay. There's a difference between taking a small object and putting pressure on the body as opposed to a larger, wider object, isn't there?
Well, it depends on what it's contacting. And certainly not a difference when you look at the size of that impactor and the size of the knuckles and the metacarpal bones.
So, for example, if somebody took a book and hit somebody off the forehead, it may or may not leave a mark. But if they use the same force and they took a high heel, the heel of a high heel, and hit somebody, there would likely be more damage with the high heel than there would with the book. Isn't that fair to say?
Well, soft tissue, but if the force is the same, you would expect the fracture to occur. You have to look at the distribution, you have to look at the strength of the bone, and you have to look at the overall force that's being applied.
Now, you said in your differential diagnosis you considered all evidence. Did you say that on direct examination?
I don't believe I did. I believe I considered evidence for a biomechanical and accident reconstruction analysis in this case.
So you didn't consider phone data?
Has nothing to do with biomechanics or accident reconstruction.
Did you consider text stream data?
I'm going to allow that.
I'll strike it. Did you consider Apple Healthcare data?
No, sir.
I'm going to allow it.
Did you consider phone temperature, battery temperature data?
I'm going to allow it.
Has nothing to do with biomechanics, sir.
I'll ask again. Did you consider it?
I did not, no.
You said it would be improper to ignore evidence. Were those your words?
For a biomechanical analysis, yes, sir.
Okay. Have you been to the scene of an accident before or a collision?
I have, yes.
Do you know what a debris field is?
Yes, sir.
And you've seen in your videos E and F, there's debris fields after the collision and the taillight brakes, isn't there?
So first of all, there's debris in the yard. What that's from, is there a collision? Was there a collision? Where did that come from? Where it was positioned? That's all conjecture and supposition. Those aren't actual facts, sir.
Can you hear my question about debris field? I'm asking.
Yeah, and I think it's
Excuse me, sir. In a collision, have you seen debris fields?
I have, yes.
Whoa. Have you seen debris fields where the taillight is shattered?
I have, yes.
In fact, in your videos, yes or no, after the collisions, in video E and F, there are debris fields, aren't there?
There are at a certain point, yes, sir, absolutely.
And so when you're looking at your studies, do you consider debris fields?
It depends on the evidence. It depends on how it was collected. It depends if it is accurate or reliable. But from a biomechanical standpoint, no. You don't need to look at the debris field or alleged debris field of a taillight cover. That has nothing to do with the injuries or the position or the movement of an individual.
Exhibit 73, please. Do you see that, sir?
I do.
Do you know what that is?
Looks like possibly part of the taillight cover.
Right. Is that an alleged part of the taillight cover, or do you think that's part of a taillight cover, sir?
I don't know specifically. It might be part of the actual taillight cover.
Well, when you studied this case and you looked at all the evidence and all these different things, did you look at these photos and see that alleged piece of taillight shard recovered from the front yard area of 34 Fairview Road? Did you consider that?
Well, I don't. Was that part of the one that was recovered by a leaf blower or not?
When you were doing your ample study, sir.
Now he's getting testy.
Yes.
What I'm
I think
asking
you should not
you
do
is,
this.
when you were looking at all the available evidence,
That's too much.
did you look at this photo of this alleged taillight shard on the front lawn of 34 Fairview Road. Were you aware of this?
No. Oh, I was aware that there was debris in the yard, but again, that has nothing to do with the biomechanical analysis. If you can't prove that the impact happened, then everything after that doesn't actually matter, does it? Because all of that would be from something else. So unless you prove the core issue at this case, the contact, the post-impact movement, the head injury, without proving that, everything else is ancillary to what you're attempting to conclude.
Do you have any evidence in your biomechanical studies how this alleged piece of taillight shard ended up on the front lawn of 34 Fairview?
I don't. No, sir. I didn't evaluate or investigate that.
Could I have Exhibit 76A, please? Did you see this photograph, sir?
I do, yes.
Is that part of a red taillight shard or an alleged piece of a taillight shard?
It looks like it, yes.
Did you consider this in your biomechanical studies, that this taillight shard was found in front of 34 Fairview Road?
Was found. Can you give me a precise distance from where the body was found and where that was found with respect to Mr. O'Keefe, with respect to a reference point?
Did you consider this, sir?
There is none, so no, I did not consider that.
Do you know how this taillight shard got there?
How it got there?
Yes.
That wasn't part of my analysis. There are certainly different possibilities of how that actually occurred.
Exhibit 99D.
He should ask, do you have a precise measurement for where this ended up? Every single time. That is.
Do you know what that is, sir?
It looks like part of the light assembly.
Mr. O'Keefe's hat?
Oh,
Did you
that's
look at
his
this
hat.
photograph?
I see now, yes.
Did you know he was wearing a hat that night?
I did, yes.
And did you consider how that hat ended up on the ground in front of 34 Fairview?
No, sir, that was not part of my biomechanical analysis. There's a number of ways a hat can end up in a yard.
Right. Is one of those ways being in a collision with a Lexus?
I suppose that's a possibility, or someone could put it there. I mean, there's a number of different possibilities as to when or how a hat may appear in a yard.
Who do you think put it there?
Well, I have no idea. I haven't seen any evidence of how it got there, and frankly, it's immaterial to a biomechanical analysis.
Do you have a theory you want to share with us about planting evidence? Is that what we're getting at, sir? By the way, the x-rays you looked at earlier, when's the first time you saw those?
I saw those when I was on the case initially for the first trial.
No mention in your report about reviewing those.
It says I reviewed medical records and reports. That's how I actually word in every report I have. I just put generally that. It refers to medical records and reports, which includes x-rays, MRIs.
Exhibit 74, please.
Christine, thank you. That's awesome.
Have you seen this photograph?
I have, yes.
Okay. In your studies or your testing, did you determine how Mr. O'Keefe's shoe ended up near the curb?
No, sir.
Exhibit 201A, please. Have you seen this photograph before?
I don't know that I have.
Have you ever seen any container that had tail light shards that matched the defendant's Lexus that were removed from his
Objection coming.
Sweatshirt and his shirt? Have you ever seen any container holding those?
I haven't.
No objection.
Well, I believe there was evidence collected like that, but yes.
Okay. Could we have 201E, please?
He said from his clothing. You can't just say from his shirt.
Have you seen this photo?
I believe I have seen that, yes.
Do you understand those are taillight shards matching the defendant's Lexus, the broken taillight?
Yes.
That were recovered from Mr. O'Keefe's sweater or shirt?
Objection.
Objection. He has to say.
Did you consider that?
I'll try. I'd rather try to reformat it than come sidebar.
He has to say pants. He can't say just sweater.
Did you know that taillight shards were collected after Mr. O'Keefe's sweatshirt and T-shirt was scraped?
Objection.
I'm going to allow that.
I need to see for a
Jurors, this will be brief.
Jurors, this will be brief. Mr. Brennan wants to say, and he's tried this entire trial, he's tried to say that these shards came from his sweater. There is no evidence it came from his sweater. It could have come from his sweater. It could have come from his pants. Could have come from both. But every time in this trial, he's tried to say it's just from the sweater. It's been objected to and sustained. If the judge allows it this time, that will be the first. The reason why is because they were collected together, they were commingled, and they were tested together. All this, they can't say where it came from because both were scraped and the total contents were analyzed. Could have come from neither. I think it came from them. I'll give the Commonwealth that. I think it came from them. I don't think they just, the lab technician added shards of taillight. It was in the bag. They also dumped out the contents of the bag. So anything that was in the bottom of the bag after they had bagged also got added to that. Can't misrepresent facts to the jury. If we just pause for a minute and say how epic closings are going to be in this case, how absolutely blindingly hot and spicy they're going to be. Oh, they didn't scrape the sweatshirt by itself. They did not. They scraped the sweatshirt and they scraped the pants and they dumped the contents of the bag all together, and that's what they got.
Thank you, Your Honor.
Okay.
After they rode around for 6 weeks in Proctor's trunk.
In your extensive study of the detail of this case, did you know that these pieces of plastic were removed or scraped from Mr. O'Keefe's clothes, specifically his sweatshirt and his T-shirt? Did you know that?
I was aware that samples were recovered, yes.
Were you aware that these samples were consistent with the broken taillight of Miss Reed's Lexus? Did you know that?
Yes.
Okay. Did you do any analysis how these broken taillight shards got into Mr. O'Keefe's clothes?
No, I did not. The first step involved with that would be to actually perform a biomechanical analysis, to look at the movement of the body, how the body was positioned, where it ended up. So without that knowledge, you can't determine exactly how or if those types of shards were deposited there as the result of an actual impact.
Your Honor, based on the last question, I wonder if the document finishes question. The objection will just right based on the question that was asked. For the same reason I just indicated at sidebar. You just reformatted. I'll try again.
Okay.
AJ just objected because he didn't say close.
Objection.
Can't say when you look at these taillight shards.
When we looked at these taillight shards that were consistent with the break in Miss Reed's Lexus, did you consider how they got into Mr. O'Keefe's clothes?
Objection. Same objection.
I understand the objection. Word it differently. Start with the different.
Yes, Your Honor. You see these pieces of broken plastic, don't you?
I do.
And you understand that these were found in the scrapings of Mr. O'Keefe's clothes?
I do.
And you understand that these broken pieces of plastic are consistent with the taillight of Miss Reed's Lexus?
I do, yes.
In your studies and reenactments, did you make any determination how these pieces of broken plastic got into Mr. O'Keefe's clothing?
No, when you look at those studies, first you have to know how the incident occurred. Then you can look at that and determine, if you want to, how that may have occurred. Because otherwise, there's, again, different ways, different manners in which that may have been deposited on the sweatshirt. without knowing how this happened, you can't just then look at other evidence and try and predict how it happened. You need the actual evidence to look at the event. This all goes to the event. You need contact with the arm, I guess apparently, to actually cause this incident to occur. And without that evidence of any of that happening, knowing how the body moved, knowing how it was hit, knowing where it ended up, any conclusions drawn off of information like this is just supposition, because you don't know the movement of the body or the vehicle. It's putting the cart before the horse.
What else do you have, Mr.
Can I have
President?
Exhibit 201D, please? Do you understand this is broken pieces of plastic consistent with the broken taillight of the defendant's car? Do you understand that?
I believe so, yes.
And do you understand this is a photograph of these broken pieces of plastic under a microscope?
Okay.
Well, I'm asking you. Do you understand
Well,
that?
if that's what you're telling me, then
I don't want you to rely on me. If you didn't see them, it's okay.
I don't recall if I saw those or not.
Have you seen this picture?
I don't recall seeing it, no.
Now looking at this photograph and seeing these broken pieces of plastic under a microscope with fibers near the plastic, is that something you would want to have considered in your analysis, forming your opinion whether or not there was a collision between Ms. Reed's car and Mr. O'Keefe?
Again, if you can't do a proper biomechanical analysis, then that evidence is not consistent. You can't determine how it occurred. You can't say that that's consistent with it. You can't just look at certain evidence and not do a proper analysis. If you can't even tell that an impact occurred, you can't look at tertiary evidence and say, well, this proves that it occurred. In order to say from a biomechanical and accident reconstruction standpoint that an impact occurred and here's how it occurred, you have to understand the mechanics and dynamics before it. This could certainly support that finding and those conclusions, but by itself, I don't know of any methodology in any study or peer-reviewed article that says you can just look at alleged evidence and then form an opinion as to whether an impact occurred.
Can you see with your eye that parts of those broken pieces of plastic are sharp?
They look sharp.
Do you disagree? Do you think they're not sharp?
I don't have an opinion as to that, sir.
We'll take a look.
Objection. Sustained.
If you look at that for me kindly, can you tell me whether you think those pieces of broken plastic are sharp?
Objection. I would allow that.
I guess they look sharp. I have no idea if they are or not. It's under a microscope. When you actually put things under a microscope, it looks much different, and it is much different than,
okay, let's go back to
looking at the normal eye.
Perhaps that can help. Not under a microscope. If you pay particular attention to the larger one in the middle, that looks like a shark's tooth. Do you see
Yes.
that one?
Yes.
Do you think, doctor, that some of those appear sharp?
Some of those appear sharp, could possibly cause a laceration, sure, as opposed to an abrasion.
Do you think that any of those could cause an abrasion?
I don't think that you could get a consistent level of superficial abrasions along the entire arm of minimal depth of less than 0.5 millimeter through impact with the glass. To have that minimal force on every part of the arm to only cause superficial abrasions would be highly unlikely.
Do you think some of those sharp pieces, if they were lodged in Mr. O'Keefe's sweater, could cause an abrasion?
It's possible if you had enough punctures and holes in the sweater to correspond with the abrasions on the arm. That would be, I suppose, that could be a possibility.
In your testing, not to belabor it, I'm just going to show you one. I want to show you video E. Could we go to video E, please?
The only thing I can think of is that Hank thinks that the jury's with him and not the defense witness.
Stop. in video E, the arm that is sticking straight out, who determined that angle, Dr. Wolf?
Yes, well, we positioned it just so it would impact in the general area of what was shown in Dr. Welcher's paint test study, which apparently is irrelevant and doesn't show the alleged position of how the arm was at impact. But yes, we positioned it in that manner.
When you say we, did you have input on the positioning of that, or did Dr. Wolf do it?
Well, I had input into how we were going to position it. It would be positioned it in that manner.
When you say we, did you have input on the positioning of that, or did Dr. Wolf do it?
Matrix issues.
Well, I had input into how we were going to position it. It would probably be both of us, I would say.
So you and Dr. Wolf chose to position the arm straight out, correct?
In that test, we did, yes.
Is there a glass in Randy's hand?
There is not, no.
A drinking glass, no?
No.
In any of your studies, did you have a drinking glass
Randy's
in
sober.
Randy's hand?
Randy's sober. He doesn't.
We did not have a drinking glass in the dummy's hand, no.
Okay. And you see when the taillight is shattering, those red things falling down. What are those?
Those are part of the taillight.
Continue a little bit, please. Stop. Did you count how many taillight pieces broke?
We didn't count the taillight pieces. We counted how many punctures or holes there were in the sweatshirt, which was 0.
If you had done this test and changed the arm angle, do you expect the damage would look different as far as the brakes in that taillight?
Well, we conducted a number of tests. It may look somewhat different, sure.
If you conducted this test and moved the arm angle, not another test, this test, but you moved the arm angle, do you expect that the brake would look different?
That the brake would look different?
Yes.
It could look a little different. I mean, certainly the brakes looked a little different in the test, but they were comparable to each other.
You do not know how John O'Keefe was standing that night, do you?
Well.
Objection.
No, I'm going to allow that.
You do not know how John O'Keefe was standing that night, do you?
If he was standing, if the impact occurred, then no, nobody knows how he would have been standing.
You would not know what his arm angle was, would you?
No.
You would not know the exact speed of any vehicle that hit him that night, would you?
Objection.
Sustained.
The debris, the broken taillight, is that traveling in a consistent or a different direction?
What do you mean consistent or different?
Is it all going in the same direction, or is it going in different directions?
No, there's some spread to the debris.
So the pieces don't all fall right in a pile with each other, do they?
They do not, no.
Continue, please. Stop. Do the majority of the pieces land on Randy?
No, they do not.
And so as they fall, if Randy were to fall, many of those pieces would not be among the immediate area of his body, would they?
If the dummy fell right there, no, they would not be.
Okay. Now, the dummy can't fall because the dummy is on a forklift, correct?
It's suspended like a pendulum, correct.
And you see in your test that the tail light, at what you say is 24 miles per hour, can be broken without the dummy's knees touching the vehicle. Isn't that fair to say?
That's correct, yes.
Okay. You can't tell the full movement and fall of this dummy the way you've set up this test, can you?
Well, knowing the physics, you can certainly determine or estimate where it would be, but no, you could release it and it would fall primarily straight down. It would twist and it would fall down.
Is there something that could affect the dummy if you let it fall? Is there something that could affect its movement after being hit?
Like what?
Gravity.
Like, could its feet be twisted and then hit another object like a curb?
Well, there's going to be very little lateral movement of its feet, but even if it did, then it's still going to fall over right where it is.
Can you continue, please? Can you see the feet, doctor?
Yes.
Are they twisting?
They are, yes.
Is that because of the rotation of Randy after he struck?
Yeah, that's the rotation of Randy. And again, as you said, that's not a normal person because there's no normal force acting on the dummy. We just have it barely touching. So a normal individual, you aren't going to twist to that extent because this is a dummy which is suspended with just a little contact on the ground.
And after being contacted by a vehicle enough to break the light, could it cause a person to stagger backwards?
I mean, you're making some suppositions here. There's no evidence that would occur in this case, and not if you're spinning like that. You're not going to stagger backwards. First, you're going to spin if you get hit with your arm, as I described in my direct. But is it possible? I can't say it's impossible, but there's no evidence of that.
Could a person stumble backwards after being hit?
Objection.
I'm going to allow that.
What do you mean by backwards? Because you'd be spinning. So what direction is backwards?
Could a person get their foot caught on a curb, and sneaker come off, and then stagger backwards and fall on their head?
Objection, Your Honor. Yeah, let's go.
I'm going to allow that.
Doctor?
Can you answer that?
I mean, I guess you could somehow predict or have a possibility of almost anything happening. You could say someone could get hit by a car and do a couple of somersaults into the yard. I mean, there's no evidence of that. So it's just supposition, but I won't say it's impossible.
Do you think John O'Keefe did somersaults into the front yard of 34th Fairview? Is that what you're telling us, Doctor?
No, I don't think he even got hit by the car, sir.
That's not what I'm asking. I've heard that. I'm asking you if he did somersaults into the front yard.
No, there's no evidence of what he did.
Your Honor, come sidebar quickly before I start.
Okay. Oops.
This is number 10, right? We're rapidly approaching that magical no sidebar threshold. Okay, the level of snark, I think the witness needs to dial it back. I think he's turning off the jury, personally. I don't like it. I think it's too much. It's entertaining, and you can tell he's winning, but it's not the style of argument that I think furthers the conversation and leads to understanding. Toys Frog is innocent. Thank you, Phil. I'll go ahead and mark you down in the innocent category. It looks like you're with it's just yourself. You're by yourself on that one, but we've got you down. This is 11. Is this 11? I said 12. No, it's number 10. I think it's number 10. We just hit double digits, just like Kai today. Happy birthday, Kai, by the way. Frog has 3 German Shepherds. He does. Keeps them out in the car during court. Not a big fan of that. But Snark begets Snark. Yeah. Hank started it. But be the bigger man, right? He is taking it personally. I agree. I think he's losing some of his professional edge when he brings the snark around. I think there are ways to testify virtually identically in substance to what he's saying without the zingers every time. We don't need the mic drop zingers, although I'm enjoying them. Cool. I do give him extra leeway when he's been asked the same question 4 times. At that point, yeah, snark away. TYO Toys, by the way, OG status. Thank you very much. So this sidebar is called by Mr. Brennan before he goes into an area that he thinks he should be allowed to go into, that the judge has probably said, come talk to me before we go there, and I'll see if I'll allow it. Come talk to me at sidebar before you go there, and then I'll allow it. Let's see. Recovery Addict, they stayed professional last time and it was hung. I think this is better. I don't know. We've got word from the courtroom that at least one of the jurors, the youngest male juror, looks uncomfortable during this testy exchange, says Sue. So at least one doesn't like it. And that could go against the defense. I mean, it depends who the juror attributes it to. Libby, 19-month member. We're somehow back at Trooper Paul's pirouette. We made it back here. The science juror is smiling slightly at the somersault exchange. She is usually very stoic. Says Sue. Camilla, thanks for sharing. Sue O'Connell in Twitter is there in court observing. She's been there almost every day, almost all of every day. Had to take a couple breaks, but at Sue NBC Boston is her Twitter handle if you want to see those directly. But she's been providing updates on specifically watching the jury throughout the trial. Which has been useful because that's one thing we definitely cannot see. Mr. Larson, we are nearly done. We expect the defense to rest today. Like, they're done. This is cross-examination. We'll get redirect and maybe recross, but we expect them to rest today. Or possibly tomorrow. Depends how long Mr. Brennan takes. He said it was only going to take an hour. He's already over that.
Could I have Exhibit 166, please?
And it was allowed.
Did you see this photograph, sir?
I did, yes.
And do you see the cut on Mr. O'Keefe's nose, the left side of his nostril?
I do.
In your analysis of whether there was a collision with the defendant's Lexus, did you consider or know that there was evidence that a piece of glass or a piece of broken plastic was pulled from Mr. O'Keefe's nose?
Objection.
I'm going to allow that.
You want me to form the question?
I'm going to allow that.
You are.
So, hold on.
Sure.
Let's get an answer, Dr. Mitchell. Your objection's noted, Mr. Jackson.
I was aware there was some piece of material allegedly pulled from the nose, yes.
Allegedly pulled from the nose?
Yes.
Okay. And that alleged piece of material, were you aware that it was perhaps a piece of glass or broken plastic?
Objection.
Are you aware of that?
Your Honor, that's not the evidence. That is not the evidence.
So,
Glass.
hold on, Mr. Jackson. Mr. Brennan.
I can reword it.
Okay.
You're welcome. Are you aware of that object that was pulled from Mr. O'Keefe's nose? What material that was?
I believe it was glass.
Did you want to know in your assessment about collision where that came from?
Well, I did evaluate that, and it's actually entirely inconsistent with coming from an impact with the vehicle.
Can we have Exhibit 52A, please? Do you know what that is, Doctor?
It's hard for me to see from here. I believe that's the drinking glass.
A drinking glass. Do you know where that is in relation to where Mr. O'Keefe was found?
I believe it was found in the vicinity of where he was found.
And could I have Exhibit 195, please? You recognize that?
That is another photograph of the drinking glass, yes, sir.
197A, please. B. C. D. And in your assessment, did you know that a piece of glass that fit the broken drinking glass was found in the street area in front of 34 Fairview Road?
Yes, sir.
Okay. 98, please.
That one piece was found in the
A
road.
little more, please.
That was
Do you
consistent.
know what that is, sir?
It's a straw.
It's hard for me to tell from
Does it
back.
look like a drinking straw?
Okay, the black, that does appear to be a drinking straw, yes.
Have you seen that before?
I've seen that photograph before.
And do you appreciate that is in front of 34 Fairview Road?
Yes, I believe that's correct.
And sir, in your analysis, in your reconstruction analysis, did you consider the broken glass found near Mr. O'Keefe's body, the suggestion glass is found in his nose, and that glass that fit the broken glass was found on the street? Did you consider all those things in your reconstruction analysis?
Well, my biomechanical analysis, I did consider especially the glass in the nose, yes, and whether that could have been as a result of the impact.
A result of what?
A result of the impact with the vehicle.
When did you find out about the glass from Mr. O'Keefe's nose? When did you learn that?
I don't recall specifically.
But was it before you came and testified last time, or was it before this time?
I honestly, I couldn't tell you. I know it was before this time. I don't know when I found out about it.
Weeks ago, months ago? Could you turn the lights on, please?
I have no idea, sir.
You don't know if it was weeks or month ago?
I don't remember with that specific piece of evidence when I found out about it.
What do you mean you don't remember it? Have you seen it before?
Well, I evaluated certainly for my report for this case. I don't know if I had known about it prior to that.
Is it mentioned anywhere in your report about the piece of glass in Mr. O'Keefe's nose?
No, it's not.
When you received that information, did someone tell you about it? Did you listen? Did you watch? How did you evaluate this evidence?
It might have been in an interview or something that it was pulled from his nose, I believe.
Okay. So you saw and listened to something?
I believe so, or was made aware of it.
Okay. Just a couple more questions, sir. I had asked you at the beginning of your examination whether you denied that receiving information certainly helped prepare to understand what was going on during the trial. Do you remember those questions?
With respect to the trace DNA, correct?
Okay. May I approach?
Yes.
This is not a sidebar. He's showing defense counsel an exhibit.
Yes. 124 lines.
I don't hold it against him that the FBI gave him information about the case. The FBI was his customer. He was working for them, providing analysis.
You've testified a few times under oath in this case, haven't you?
I have, yes, sir.
And you've testified recently for a short bit in April, didn't you?
I did, yes.
On April 28, 2025, did you testify in this very courtroom?
I believe I did.
Under oath?
Yes, sir.
Like the oath you took today?
Yes, or yesterday.
Now, when I read this, I'm not attributing this in any way to the defendant's attorneys. I'm going to read you this just for clarity. You were asked, did they inform you about witness testimony? And what did you say, sir?
They did inform me, yes, about testimony in situations and events that came forth in the trial that I was not aware of.
Those are your words?
Yes, sir.
Page 125, line 7. I'm going to ask you if this is your sworn testimony, sir. On page 125, line 7, I'll read the question. And if this is your answer, you should read the answer. Were you asked, and by calling and raising issues and telling you information, even if you weren't requesting it, it helped prepare you for your trial testimony, didn't it? What did you swear?
I said it certainly helped prepare me to understand what was going on during the trial, yes.
Oh, my goodness.
I have no further questions.
All right, Mr.
Okay,
Jackson.
somebody get Mr. Brennan some Desitin,
Okay.
because that rash is going to need some cream. Wow. 11. We're at 11 now. 11. I have two witnesses this trial have frustrated Mr. Brennan badly, and Mr. Rentschler is the top of that list. Dr. LaPastada was very effective at it as well, but not anywhere near this degree. Destin, not a sponsor, by the way. You said 12. Is it 12 now? I said 8 twice. Whose job was it to keep count of sidebars? I know I can go back. Okay, let's see. Beginning the day, right? One. Two.
May I inquire?
Yes.
Thank you. Dr. Rentschler, you were just asked a couple of questions about they provided information about the prior trial, correct?
Correct.
They is no one associated with the defense team, correct?
That's correct. No one associated with you, and they provided information, and again, it let me know what was going on, but it didn't affect my preparation or my opinions. It in no way changed any of my opinions or what I testified to.
Thank you for that.
To get through this, I'm going to let you just answer the question.
Sorry, Your Honor.
And with regard to, and I appreciate that, Mr. Brennan asked you a couple of questions about they being your employer. Do you remember those questions at the beginning of his cross-examination?
I do, yes.
Who is your employer, actually? The actual employer that you work for?
ARCA.
Okay. Wasn't them.
No.
It's a client, correct?
It was a client, that's
completely
correct.
separate entity that hired you for that work, correct?
That's correct, yes.
Thank you. You were asked about a fender vault collision, and you said, well, this wasn't a fender vault, right?
Correct.
What is a fender vault?
A fender vault is when you're hit by the front of a car and you're moving across the car. So you're moving across the center towards the driver's side of the car, and the car hits you. You go up over the car and you fly over the fender to the driver's side of the car. So you vault over top of the fender.
Dr. Rentschler, where is my, as I stand here, where is my center of mass?
Right about your belly button.
Right there.
Yes.
So what would happen if I was hit by a vehicle, front collision, and the vehicle struck me below my center of mass?
It's going to flip you. Your center of mass will go. You'd go right up. If it was coming right at you and it hit you at your legs, you'd flip right into the hood or over top of the top of the car.
Is that what's described in the industry as a fender vault?
That is part of a fender vault, yes, but it's at an angle. So instead of going direct back, it's because if the person's walking across and you get hit, you fly kind of back and over the top of the fender.
Did that set of circumstances, physics, have anything to do with your analysis in this case?
No, none whatsoever. The profile of the car is completely different, the back of the SUV.
You were asked several questions about the debris field in the test F as in Foxtrot. Well, actually, you were asked about both test E and test F. Test E being the 24-mile-an-hour impact to the right arm of Randy, correct?
Correct.
And test F, the full rear impact, center of mass impact, correct?
Correct.
You were shown several photographs, exhibits of very tiny, tiny shards. Do you remember that?
I do, yes.
I'll get to that in a second. You were also shown some photographs of pieces of plastic that were claimed to have been found at 34 Fairview. Clear plastic, piece of red plastic, correct?
That's correct, yes.
In your review of all the data in this case, do you know when those pieces of plastic got to 34 Fairview?
I do not. No.
Do you know how those pieces of plastic got to 34 Fairview?
I do not, no.
Do you know who put those pieces of plastic at 34 Fairview?
I do not.
Were you aware in your review of the police reports that none of the plastic that you were shown was found at the time John O'Keefe's body was discovered and the area was initially searched?
That is correct, yes. I was aware of that.
You indicated that the cut on Mr. O'Keefe's nose, the right side of his nose, was inconsistent with coming from a vehicle, correct?
Correct.
Can you describe why you came to that conclusion?
Well, if you're standing at the back corner of the vehicle and it strikes the arm, and let's be clear, if nobody wants to say where the arm was or how it was positioned, if they're claiming the abrasions are a result of the fractured taillight, it has to strike the arm. You have to be standing like this. The debris goes forward with the vehicle. So it's with your arm like this, it already passes by the person. And if there would be any contact whatsoever, it would be with the right side of the face. The shard can't come out and then make a right turn and then somehow embed itself on the left side of the nose. That's entirely inconsistent with the fracture and how the glass and the cover would actually move.
Dr. Renshaw, you were asked a series of questions about a hat. Do you remember that?
I do.
About some shards of plastic material, correct?
Yes.
About a drinking glass?
Yes.
About a drinking straw?
Yes.
Doctor, if there was no collision, does any of that matter in terms of your biomechanical analysis and your reconstruction in this incident?
It does not.
Why?
Well, because if there wasn't a collision, it wasn't that debris or those items weren't a result of that impact. You can explain how that got there, I believe, easier than if you can't explain how the impact occurred. If the injuries don't match up, if you can't even prove what happened, then you can't use information or evidence if you have no idea how it got there to try and prove what you don't even know what happened. Scientifically, it makes no sense.
Scientifically, is the first question that has to be answered is, was there a collision?
Objection. Sustained. You have to watch the foreman question.
Of course. In your expert opinion,
what's the first
based
question
on all of your review of all of the data in this case, all of the testing that you've undertaken, do you have an opinion as to whether or not there was a collision with John O'Keefe?
I do.
Yeah, I'm sustaining that. You're on this call.
In your view, was there evidence of a collision with John O'Keefe?
Objection. Sustained.
In your opinion, were any of the injuries that you saw suffered by John O'Keefe consistent with having been struck by the subject Lexus?
No, they are not.
Do you hold that opinion to a reasonable degree of scientific certainty?
I do.
Thank you.
Okay.
Mr. Brennan? Any famous last words?
Doctor, you just said that you do not believe that there was a fender vault collision. Could it have been a clip?
Could it have clipped Mr. O'Keefe?
Yes. Not hit him, but clipped him.
Well, I don't believe that's consistent with the evidence and what occurred. I mean, someone can get clipped by a car, sure, but in this case, no, I don't believe the evidence indicates that's what occurred.
The glass. When you learned of the information of the glass in Mr. O'Keefe's nose, when do you think it was that that glass was pulled from his nose? What date?
I think it was the morning when his body was discovered.
January 29, 2022?
Yes, sir.
Somewhere around 6:15 a.m., is that your understanding?
Sometime when his body was discovered, that's correct.
Do you know or understand that, did you see any evidence that Mr. O'Keefe had a drinking glass outside of 34 Fairview Road that morning after he got out of the defendant's Lexus? Do you understand that?
What do you mean evidence?
Drinking glass. Did you hear anything about that in your review about?
What evidence would there be? Is there a video or a photograph, you mean, of him holding a drinking glass? Because otherwise there's a drinking glass there, but there's no evidence that he had it.
We have a clip, right? Okay. Judge?
We have a clip.
Can I come sidebar?
Okay.
What number is this? Who's counting? Who's in charge of the sidebar counter today? 13, Patriot. 13, unlucky 13. How many did we have on the no sidebar day? I'm beginning to think we have just as many sidebars on no sidebar days as we have on sidebar days. Look at Mr. Wolk there, straightening the chair for Mr. Yannetti. That man needs a raise. I believe 13 is the number of on the consensus. We had Baker's dozen. Didn't we have Baker's dozen before? Or we had 14? I don't remember. So last time it was 13. Oh, it was 12 on sidebar day? So there is a clear difference. $14 yesterday. Okay, thank you, Raya, for this clarification. I appreciate that. By the way, I on some I don't know why. What's the people that study bugs? I like your profile picture, Raya, with the ants. I love it. 14 on the no sidebar day. 13. Are we on 13 now? $13 today. We just need one more. Entomology. Entomology. Study of bugs. I think there's a video of John O'Keefe leaving the waterfall with a drink, but that doesn't show him with a glass at 34 Fairview. 13 today. So 13 today, 14 on no sidebar day. It's going to be a clip of Karen's documentary. Possibly. But did she say he got out of the car with the glass? She did? Okay. I'm sure that would be better evidence for Mr. Brennan to bring in than, say, like the waterfall security video showing him leaving the bar with the glass. Because it's closer in time and it's a statement by the defendant, which would have a more powerful effect on the jury. That is hearsay, but it's a statement by an opponent. Defendant statements are allowed to be brought in by the prosecution. Statement against interest by the party opponent. Hank is way snarkier and way more of an off turn, says Lisa. Wants to show another video. It's only 3:30. Kim, no, they're not. They're not watching. They're not watching us.
You were asked about whether or not any plastic taillight shards were found near Mr. O'Keefe's body. Do you know the limits of the search that the Canton Police Department did around Mr. O'Keefe's body? How small of an area they searched when they first went there?
I do not know, sir.
Did you ever see a video of somebody with a leaf blower blowing snow off the ground?
I did see that, yes.
And did you see the confined area in which that happened?
Well, I mean, I saw the area where he was blowing with the leaf blower.
Have you seen any information or evidence whatsoever that the pieces of taillight that were found after that search, have you seen any evidence that they were found in that exact area, or were they found in different areas on the lot?
I'd have to go back and look. I don't recall specifically.
And so when there was a snow blower or a leaf blower search in that area, there would not be a piece of plastic taillight to find if it was never there, would there be?
If it wasn't there, you wouldn't find it? Is that what you're saying?
That's what I'm saying.
Sure.
Okay. Did you notice in the injuries to Mr. O'Keefe, most of them are on the right side of his body?
Well, we have the abrasions and then a half-centimeter abrasion, and then we have the laceration and scuff on the left side, and then the skull fracture. It's a little bit to the right, but it's mainly on the back of the head.
And the bruise on his knee?
That's the half centimeter. It's not a bruise. It's a half-centimeter abrasions, about an eighth of an inch.
When you're conducting an investigation or you're doing your analysis and you keep saying the physics and the physics, do you add a little bit of common sense in the equation when you're considering the evidence?
Well, you can sit back or step back and look at whether what someone's claiming makes sense in the bigger picture.
So when you have common sense and you look at the big picture, it's not just physics. It's considering all of the evidence, right?
Well, it depends what you're looking at. To certain parts of it, the biomechanical analysis, you look at the physics. It tells you what it is. I mean, if you don't like it and you don't think it fits, well, sorry, it is what it is. That's the science. So you have to step back. I mean, you can look at it the bigger picture if things make sense. You know, if somebody was standing on the side of the road with their arm like this while an SUV backed up at them and they didn't flinch or they didn't put their arm up, that's kind of the smell test bigger picture. That doesn't make sense. But the physics, you can't deny it. You have to accept what science tells you.
You can't deny it. That's the line you were laughing about in the documentary as one of your answers that you were all celebrating, isn't it?
Objection.
Isn't it?
The objection sustained.
How'd that taillight break, sir? How did it break that night?
How did? Oh, I don't know. There's no evidence of how it broke.
I have no further questions.
All right. You're all set, Dr. Lenchley.
Thank you, Your Honor.
Is there an objection?
There is an objection. Sidebar. Come sidebar.
Subject to us discussing it. Mr. Jackson. Mr. Jackson. Subject to me taking a look at it and us discussing it. It's not coming in right now. Okay.
Is that the defense rests?
They've been marked for identity. Jurors, I want to see counsel for a couple of minutes over here.
Sidebar number 14. 14. So apparently this is a no sidebar day. We didn't know it was going to be this way, but it sounds like she wants to see something before she allows it in. Mr. Wolf says it's 14. 14 sidebars today. Mr. Wolk says, Mr. Alessi. He's like, I know, I walked every one of them. Sophie, yes, it happened. It happened. It's on video. She bumped into the car. The car moved a little bit. There was no evidence found or testified to that any plastic fell off the taillight at that time. And when it occurred, it was after the time that allegedly this incident occurred with John O'Keefe at 34 Fairview. But yeah. All right. It's 3:30. Or 3:30, as the judge would say. Half past. If you don't like the physics, you can step back and ignore the science, but doesn't pass the smell test. Could have fallen into the taillight housing. I don't see that. I haven't broken my taillight yet. Maybe we'll do that during jury watch. But I don't see the pieces falling in. Like, if they break, it's putting tension on a very rigid piece of plastic. I would expect an explosion of plastic, a snap, pieces flying, cracks in multiple places. I would not expect all of them to fall inside. Enlarge yourself. I'm feeling embiggened. How's that? You get big and small me at the same time. There's only about, if you look from this angle, there's only about an inch at most between the outer layer and the inner layer. By that I mean the diffuser and the red cover on this. All right. Did the defense rest? It sounded like Mr. Jackson, he was away from the microphone, but he said, subject to those being admitted, the defense rests. But then all the attorneys are like, wait. And Mr. Jackson tried to clarify with the judge, are they being admitted? She says it's not coming in at this time. And he's like, well, it's now or never. So now they're just gonna figure it out. Maybe RA can adopt Randy. I don't know where I would put a Randy. I don't have room in my studio for a Randy. It is full. JD, for us trial addicts, Lori and Karen Reed trials should have been staggered more. I wish the courts would get it together and put the big cases, not overlapping. Maybe a small Lego Randy. There's an idea. Do we have a Lego crash test dummy? Is there one? Bailiffs are collecting the lanyards from the press. They're like, give it up. Give it up. There we go. All the lanyards will be redistributed tomorrow. Yes, there's a Lego crash test dummy. Ooh, I have to look into that. There won't be any more testimony today. I think defense is done, Baca. I think they're all done. You need a Randy to do tests on for all our murder trials. Okay. My budget is sort of more in line with the burn pile murder dummy. For that one, they use the sparring dummy, the punching bag dummy. That's like the black round base that you fill with water or sand, and then you got the body, the torso, and the face. No arms on that one. No arms. That's the one they put in the house and they shot. They put a bulletproof vest on him and shot him a couple times. That's more my budget. The actual dummy, Randy the dummy, that's used for fireman carries and things like that, can run $1,000 to $3,000 depending on the model. And then when you get into real crash test dummies, then add 2 more zeros, and they get really spendy. Crash test dummy fund, says Regina. I'll allow it. Crawford, contribute to the fund. Maybe we could accept a donation of a used crash test dummy. Is there a point when they need to be rehomed? When they're like, sir, you've served a good dummy life. You've seen enough crashes in your day. Now it's time to retire you to the happy land of smooth sailing and rainbows. And then we could intercept him then and just subject him to more crashes.
We will see you tomorrow morning. Those same cautions, please do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it and let us know. We'll see you tomorrow morning.
All right, the jury.
Write-offs only help so much as that I have a tax burden to count it against. At some point where you just spend too much money, you just don't have money for anything. So we should get to hear some arguments here just before, well, the defense is going to rest. We should hear some arguments about a couple things right now. Possibly the corrective instruction should be given to the jury regarding
All right, so Mr. Brennan, I'm going to take a recess. You go ahead and look at that PowerPoint. I'll come back out in 10 minutes regarding the PowerPoint.
Mr. Brennan, you are court-ordered to view a PowerPoint. Talk about cruel and unusual punishment. PowerPoint should not be a thing you can court-order people to watch. 10 minutes. It is 3:38 right now, so around 3:45, 3:48. We expect Mr. Brennan to, maybe he'll be done early. We got a tax write-off of an arm and a leg next year, and a head the year after, divided up. Rebuttal tomorrow with Dr. Welcher. Ninus says, I just sent you a link to the burner phone. Did you receive it? Let me look. It's loading. Hold, please. Shout out to TACPay on the replay crew right now. Just posted something on one of the videos. You'll see this tomorrow. It hasn't posted yet. Linus hasn't come up yet. Try this address right here. Yes. We are accepting surplus crash test dummies. My P.O. box is literally the size of a postage stamp, but if you send it via USPS, United States Postal Service, I will be able to receive it. They will stick a small note in my P.O. box and then a large package behind it, and they'll hand it to me over the counter, which is against postal regulations, but that's protocol where we are. Let's see. Taillight giveaway. Sort of attached this taillight. Is there redirect and recross on rebuttal witnesses? Yes. I'm not sure about, well, there's definitely cross, but I'm not sure about redirect and recross. That's up to the judge's discretion. Don't forget, guys, defense needs to ask for a judgment of acquittal. That'll happen tomorrow, I'm sure. Closing arguments tomorrow afternoon or Friday. Hopefully the jury comes back with a quick verdict, because I'm going camping Tuesday, which means that's when they're going to have their verdict. I know, but we'll have to live stream the whole thing. Poll us. We have to wait till rebuttal's done for the poll. I'm only going for one day, and I'll be live streaming while I'm there, so it's all good. Did defense officially say rest? It was really hard to hear. Let me go back and play it for you during the break here. Fast forward. Fast forwarding through all of today's video. Actually, need to bring in a new one. Just restarted. There we go. Okay. Let's wait. It was right at the end of the sidebar, right? Or right before the sidebar. Right before the sidebar. Okay, here we go. Ready?
Us discussing it. It's not coming in right now.
Did you hear that? Did you hear that? The defense rests in there? Let me Let me do some work on that. Nope, that's too fast. We'll take it from right here. We're going to edit this live since we've got time.
Is there an objection? So
I think we have to go back further than that. Oops, I just deleted everything. We're in black. Okay. Jump forward. Jump forward. A little before this one. Okay, from right here. Ready?
Thank you. No further questions.
all right, you're all set, Dr. Lenchley.
Thank you, Your Honor.
Move for admission.
Is there an objection?
Objection, there is.
So, subject to us discussing it. Mr. Jackson? Mr. Jackson? Subject to me taking a look at it and us discussing it. It's not coming in right now. Okay. They've been marked for identity. Jurors, I want to see counsel for a couple of minutes over.
So that's the part we're going to use. So let's go ahead and clean that up just a tiny bit. Get the audio fixed a little bit. Do some voice isolation. Wait for it. There we go. Dialogue leveler. We're going to raise. Reduce loud dialogue. Actually, we're going to lift soft whispery sources. Does that work? Now let's try that again. Ready?
Further questions.
All right. You're all set, Dr. Lenchley.
Thank you, Your Honor.
Is there an objection? So,
We got rid of all the court noise.
subject to us discussing it. Jackson.
Mr. Jackson, Mr. Jackson. Hang on, it's still processing. Sorry, I got ahead of it.
And us discussing it. It's not coming in right now. Okay. They've been marked for identity. Jurors, I want to see counsel for.
Okay, I didn't hear it. I didn't hear it. Let's go back here while we wait. I'm going to turn down the voice isolation a tiny bit. Play it again, just audio only.
All right. You're all set, Dr. Lenchley.
Thank you, Your Honor.
Is there an objection? So, subject to us discussing it. Mr. Jackson? Mr. Jackson? Subject to me taking a look at it and us discussing it. It's not coming in right now.
Okay, sorry, I'm playing it before it's done processing, so it's causing a little clipping.
Okay.
That's the part right there. Just that little right here. Mr. Jackson, Mr. Jackson. All right. I did not hear him say it, but because I took it out, it was just too quiet. If I turn off the voice isolation and just leave the background reduction and lift soft whispery sources, play the whole thing again with background noise.
Thank you. No further questions.
All right. You're all set, Dr. Lynchman.
Thank you, Your Honor.
Is there an objection? So, subject to us discussing it. Mr. Jackson? Mr. Jackson? Subject to me taking a look at it and us discussing it. It's not coming in right now. Okay.
That was it. With that, the defense rests. With that, the defense rests. So I heard it. Sue heard it in court as well. Everyone said it in chat, but I was not looking that way. She's in the courtroom. She heard it. Sue said on X the defense did rest. All right. What's not coming in right now? Well, it's actually going to be fought over right now. I think it's the PowerPoint presentation that was brought in with Dr. Rentschler, that new version. Mr. Brennan has objected to it. It's pending an admission. It's a soft rest. It's like a settee, a couch. It's not the full bed. They have not distributed their load across the whole bed like Dr. Welcher did. It's a soft rest. They gently sat down. Like a siesta, a partial rest. Is Welcher coming? Yes, he is. He's coming tomorrow. It'll be rebuttal. Back to the state. Mr. Brennan will be leading. Defense will be back on cross-examination, and that's going to happen tomorrow. But we're waiting right now to see if we can get a hard decision. See, it's supposed to be right now. They've had 10 minutes. So let's go back here and wait. You can't have a new PowerPoint, but Brennan could bring in his witness for rebuttal with his full PowerPoint. You can't make this stuff up. They cut all the words off the PowerPoint. Those were the words they objected to. They cut all the words off. And now Mr. Brennan is still objecting to the newest version. There's still an issue about an instruction to the jury, which has not been handled yet. The judge says we're putting it off until the charge conference. Discussion of whether or not there needs to be an additional instruction to the jury regarding Mr. Brennan manufacturing evidence. And oops, I made a mistake. Those holes were actually caused by the trial, the analyst. What about the instructions for the jury when Brennan misled the jury? That's the part they still have to discuss. Was there ever a decision regarding the missing witness motion? If there was, I missed it. I think it was rejected. That they were not giving the missing witness instruction. Criminologist, that's the word, not analyst. Thank you very much, Daffy, for the correction. Defense will need to bring their A game for the charge conference this time. No trusting what will get done. Bud Dial, I wonder who it is who's going to be over that. Is that going to be Mr. Yannetti? Is that going to be Mr. Jackson? It takes a brilliant legal mind who can look at both, say, yes, that is legally correct, and it matches this particular circumstance. Does Brennan do both closings for the state? I think Mr. Lally has done almost nothing on this case. We've had 2, maybe 3 witnesses that were heard by Mr. Lally, in my memory. Do you think the Murdaugh case will become a new trial? Oh, my goodness. Please, no. Did I say that out loud? I hope not. I hope not. Amber, a lot of us are ready for this to be over. This has been a difficult one on many levels. Proctor never made an appearance. If you had told me at the beginning of trial 2 that Mr. Proctor was not going to take the stand, I would say, baloney, you're full of it. I never would have believed it. But here we are at the conclusion of the case, and Mr. Proctor has not been called. KK Girl does the math on the objections sustained for the Commonwealth versus for the defense today, 94% to 35%. Honestly, I look at that and I say, that looks a little bit high. It didn't feel like 35% to me. But wasn't Proctor responsible for all the sirens? Oh, he's got some pull. Adam is here. Adam Elio, not from Canton or the state police. Nusky says shame. Amber, let's check mod chat really quickly. If I can find it. This is gross.
Gross.
Okay. Gross. Let's record this one really quickly, shall we? Let's see what sound bite can I get rid of really quickly that we won't ever need again. I will delete it. It will be gone forever. How about, what's this one?
Got a lot of iron. I think we can put down a lot of retardant today.
Thank you, sir. You're my new best friend.
Let's get rid of that one.
Have a good day.
Let's get rid of that one. That's from the fires. We'll go ahead and clear that. It's gone. Now record a new one. 3, 2, 1. It helps if I plug in the phone so it actually works. Try that one more time. Stop, delete, clear, record, and go.
Gross.
That's super quiet. That'll never do, Amber. Hang on one second. We'll get full volume here.
Gross.
All right, got it. So now we have it recorded.
Gross. Gross.
Okay. I'll make gross now. It'll take a little bit. We need the ooh. Did she say ooh? Or was it just gross? Was there an ooh before it? Or oh gross? Amber, they're saying we need more. I need the ooh. Yes, she did. There's an ooh. Amber, get to work. Tell your boss whatever assignment he's got assigned to you can wait. No, just kidding. If you're available. Love the full version.
Thank you, sir. You're my new best friend.
Oh, no. Ivy, I didn't get rid of BF. I just got rid of it on my sound box, on my mixer. I'm not getting rid of thank you, sir, you're my new best friend.
Happy birthday.
Thought it was ooh originally, but then realized it sounded like oh. Yes. Thank you, Samantha, for listing.
Back, taking it easy.
For listing some of the commands that are available.
Alex stole it as well.
We don't have tofu yet. Have not done anything with tofu. We typically want to have sound effects that can be used in many different trials and many different settings. Because they're now all triggered and the system's crashing.
I'm not a cat.
Are we going to address subject matter jurisdiction?
There's nothing in the order that restrains you from talking to cats.
Thank you. I don't like podiums, Your Honor.
Thank you, sir. You're my new best friend.
We need all talk slower.
The zombie apocalypse
They were talking
may
over
be
each other.
upon
I don't
us.
think that's going to be a big soundbite.
Bring the jury. I'm not a camel.
Don't miss the forest for the trees.
I think I'm about to catch a whooping.
Hear ye, hear ye, hear ye.
Okay, I see the spread the load versus gross on TikTok. I've seen that one. I'm not going to put the two together. I don't think that's appropriate for a sound bite.
I'm not a cat.
But all right. I don't like podiums as a wild statement to make.
I'm not going to argue.
Never
about
would have expected
semantics
that
here.
in court.
Somebody just sent me a video of roaches fighting. I don't know who won.
Didn't I make big for you guys?
It's bigger than you. It's bigger than me. It's bigger than all of us.
Oh, that's the one I couldn't get to work properly, right? Okay. The 10 minutes have come and gone. We're now approaching 20 minutes of delay. Mr. Brennan needs... It was too big. It was too big of a soundbite.
Thank you, sir. You're my new best friend.
Dr... Was it Posada? Can't never get her name right. The way she said BS, it was too quiet. It was too muffled. It's not what I can grab. It needs to be a nice, clear sampling. Never did COG. No. Find it for me again and catch me on a break time. I can call in and do a clear BS. Greeners, thanks for the volunteer. I'll pass on that one. Pass.
I'm not going to argue about semantics here.
I don't think anybody wants a third trial. I think resolution is, it's time for resolution.
Bring the jury.
Is Sidebar working? I don't know.
I think I'm about to catch a whooping.
I think it was working.
Shame on you, sir.
Did I get the second clip? Let me look. Let's listen to the second clip briefly.
There's nothing in the order that restrains you from talking to cats.
Why?
Have them send someone with more experience.
Why?
Amber, it's trimmed too tight. It's a why? I need a little bit more space on the front and the back.
Why?
All right. Still waiting for the ruling on this PowerPoint. I like semantics. He was perfectly cast. Should do. I'll allow it.
I'm not going to argue about semantics here.
Needs to be perfectly clear. If we can find a good, I'll allow it. And by clear, I mean no other voices, no other sounds, no like binder opening, closing, no zippers, no sighs, no breathing, no. I mean, we can take out the fan noise if it's like
I'm not a
in
camel.
the background. I can take that out. But yeah, this is the longest 10 minutes ever. Pretty sure there's a sidebar going on as well. What happened to the counter of this trial? The counter is here. It's just been hiding. We're up to 284 for sirens and sighs. It's a lot. It's a lot. It's not the highest counter we've ever had, but it's a lot. Linda, if there's a third trial, I don't think we're going to cover it. Nope. This is crazy. Did your wife notice the loss of chocolate yet? No, she is not home. She's in Raleigh, I think at a museum right now. Time is weird in Canton. It is 4 p.m.
front of the Walmart.
So they should be done. The judge should be back by now. Any word from Sue? Let's see. Jurors have been dismissed. She confirmed the defense has rested. Brandy Churchwell comes out with this tweet. Total for today, Hank objected 31 times. That's with 29 sustained. That's 94%. And AJ objected 46 times. That's 16 sustained. Thank you, Brandy, for the stats on that one. I'm going to retweet that. 94 to 35%. The 35% does seem high. In the Lori Daybell trial, both the state and the defense have rested their cases. Closing arguments next week.
Happy birthday. You look good.
We're still waiting for a decision from the judge on some motions, and maybe we might even hear some argument on some motions. I doubt it because it's 4 o'clock and she
There's
sends the
nothing
staff
in the order
home.
that restrains you from talking to cats.
Thank you.
When are we going to break for lunch, Judge?
Okay.
Have them send someone with more experience.
The funny thing about the ham sandwich comment is that that's the second time we've heard
Happy birthday. You look good.
a ham sandwich in court. Once we heard you can refresh a witness's testimony with a ham sandwich. And so this
Somebody
is the second
just sent me
time.
a video of roaches fighting. I don't know who won.
Squirrel.
Interesting. Allegedly has posted the ham sandwich saga with the baby lawyers already. Amber sent a new video. We'll listen to this one really quickly.
Why?
Perfect. Perfect. Okay. So while this goes on, we'll go ahead and... Oh, no, we're back. We're back. Sorry. It's never going to happen now, Amber. Let's hear some quick rulings.
All right, so I had a minute to look at the PowerPoint. Are you in agreement on the PowerPoint?
We're not. I do not want to admit it. I don't think it's substantive evidence.
Okay. Mr. Jackson?
It's exactly the substance of this.
Which was not objected to, right?
No, the court keeps saying that, yes, there were things that were less like evidence, so yes, there were things that...
But did he object to the PowerPoint coming in?
It's been, we're all under pressure. I don't know what Mr. Lesson's going to do regarding the PowerPoint. That's the question. The question is whether this PowerPoint is admissible, and it is. There's nothing in it. We've taken out all hearsay, discussion, the opinions or thought processes. These are all the tests that were completed and done, exactly as Dr. Wolf's PowerPoint was done. Dr. Wolf's PowerPoint is in evidence. This PowerPoint should be in evidence.
Is there anything in this PowerPoint by way of videos that is not already in through Dr. Wolf?
I believe the video of the drop test is in Dr. Welch's PowerPoint. There are most of the videos are included. Oh, no, I'm wrong. Things have been slowed down. So the videos are the same, but the videos that Dr. Rinschler used because of the side of the case that he was handling, the biomechanics side of the case that he was handling, were slowed down significantly to show the deformation of the arm, the force impact on the elbow, the hand, forearm, about which he testified. So what he did, and I remember asking him this, before I ever saw the PowerPoint, is there going to be anything different? He said, I use the slow motion cameras more than Dr. Wolf does because I need it.
Okay, so I need you to tell me tomorrow which slides specifically answer that question for me. Okay, whether they're in evidence or not, and which ones are not, regarding the videos.
Is the board suggesting that it's not going to let just the entire PowerPoint out?
Maybe. I'm going to take a look at it. There's an objection before me now,
I realize that.
so I have to rule on the objection. So I will take a look at this, okay?
Okay.
So if you let me know, and if you want to let me know tonight, I can let you know first thing tomorrow. All right.
Have you heard briefly?
Yes.
Very briefly?
Yes.
I am objecting. It's not admissible. It's hearsay. It's a strategic decision. The past introductions have been strategic. The defense did not object to Dr. Welchers. I did not object to Dr. Wolf's, but that was a strategic decision. I'm objecting.
Okay.
The defense objected to Shannon Burgess. Only a select amount of documents were allowed. I wanted the whole thing in. I was precluded properly from introducing it because it was hearsay and they objected. I'm objecting.
Okay.
There's no hearsay. They objected to certain slides. We took out the slides. If they had an objection to the PowerPoint, they should have proposed that objection before it was displayed for the jury.
Well,
The jury has now seen the entire PowerPoint. I mean, it's tactical. It's not strategic. It's tactical. They still like it because it hurts their case. If they didn't want to get certain things before the jury, which is exactly what admitting it into evidence does, brings it before the jury so that they can see it, they should have objected in a timely manner. When they objected, they chose certain slides, certain data on certain slides, and we took all of that out at their request and at the court's instruction. We did that with the court's instruction, with the Commonwealth's instruction, and there was no objection to playing it before the jury. Given the fact that it's been displayed not in part, in whole, as it now sits before the jury, sits before the court for quadruple K for identification, it should be admitted.
Okay.
Just like Shannon Burgess. It's no different.
All right.
Shannon Burgess's PowerPoint is in evidence.
So, Mr. Jackson, when you let us know which slides answer my question about slides that are not in evidence and you want to put in evidence, the videos, just the videos, let me know that. And if need be, I'll hear you all on this tomorrow morning as well. Okay?
Sidebar first
All right.
in the morning.
Is that it for today? Will we see everybody just tomorrow morning? What else do
Mr. Leslie needs to, I didn't mean to interrupt.
After the defendant rests, we will not be calling any witnesses, putting on any further evidence.
Okay.
No rebuttal.
All right.
No rebuttal.
Your Honor, it's late in the day. We would like to review our motion for required finding of not guilty after the close of all evidence. It won't be a lengthy argument, but I'm happy to be heard on that in the morning if the court prefers when we got tomorrow morning.
Okay. Is that all we have left now? I have no idea what Mr. Alessi wants to talk about, but would it...
I'd like to respond to that, Your Honor, and the answer is, given Mr. Brennan's answer with no more witnesses, my issue is moved.
Okay, great. So...
The only other technical thing is we need to move in the 3 items of evidence, the documents associated with the sweatshirt. I think they've been marked for identification.
No, they were marked as evidence, right?
They're marked as exhibits.
Yeah, they're exhibits.
But no, they're come into evidence, Your Honor. I mean, a ruling that
Are they...
I thought they were marked as identification, not evidence. If they're in evidence, they're in. If it's identification.
So I need to find that. It would be my intention that they get put into evidence. I'm not going to display them and bring a jury in just to see those at this point.
I'm not asking for that.
Okay.
As long as they're in evidence and I can use them in closing argument, then so be it.
If I can, for clarity, Your Honor, there are exhibits. I have Y.
So that's not an exhibit, Mr. Alessi, if that's how it marked. That's identification.
I have a different parlance. I'll use this court's parlance. Yes. It's YYY, ZZZ, AAA, BBB.
So that means that, all right, so that's for identification. Letters are identification, numbers are exhibits.
Your Honor, I understand that. We all know what we're talking about, and Your Honor agreed that they're going to be in evidence.
Right. So, and I've ruled that they're in evidence. I just need to know for this record whether they're in evidence or not. What you tell me, you just told me they're in evidence. They're not. They're exhibits. They're identification. Now they will become exhibits. Can we do that now? Do we have them? Where are they? Oh, Jim, they're in there? Okay.
Yeah, and Your Honor, my whole point in wanting to be heard is that they're not in evidence, and I want to make sure they get it. That's my point.
Because once everybody rests, it's closed. It's like sealed. That portion of the trial is closed. You can't just
What
add more
number
evidence.
are we at, Madam Court Reporter?
Exhibit 230.
Okay, and we'll do A, B, C, D.
It should have been done at the
Was
time.
it Y, Z, A, and B? I think I have.
Mr. Brennan, Mr. Lally, sharing a private moment.
I don't think I have it. Counsel, I'm not sure I have those.
All right, so we will make, so as of now, they're in evidence. Tomorrow we need to physically put the sticker on those.
Can I just get the numbers before we wait?
Yes.
230A.
I'm sorry, say that one more time.
230A through C. 230C.
A, B, and C. Those are the X-ray images, I believe. Post a note to Jim.
All right.
Counsel, there are four.
Four of them,
A through D.
A through D.
Just so the record, this is limited in saying different things. They were marked for identification as triple Y, triple Z, quadruple A, and quadruple B.
Okay.
And all I need to do for my records is figure out which one is which in terms of the whole court's marking. So as we do that, I'm good and I'll get out of here.
We will do that first thing tomorrow morning.
That's fine.
All right. We will, so everyone is in agreement then. I will let you have tomorrow without the jury. We'll have our charge conference here in person. Then I'll give you the rest of the day to get your closing arguments ready. I'm imagining that you don't want to argue tomorrow morning at 9 o'clock. Is that fair?
That's fair.
Mr. Brenner, are you in agreement?
I'm in agreement. I'm not interested in arguing tomorrow.
Okay. All right. So we'll give you tomorrow. We'll have a charge conference tomorrow. I'm going to ask the court officers to call the jurors tonight as soon as possible. This is great that you did it. I was going to give you until 7 o'clock tonight, but if you're certain, then the court officers will call the jurors now and let them know they don't have to come in tomorrow. And then when they come in Friday morning at 9 o'clock, we'll do arguments and charge. Tomorrow morning will be the charge conference. Since we don't have jurors, do you all want to come in at 10 o'clock instead of 9 o'clock?
That would be great.
Does that work for the Commonwealth as well?
Yes.
Okay. So I'll see everybody tomorrow morning at 10 for the charge conference. Do you have them now, Jim?
I do, Judge. And just for the record, YYY, ZZZ, AAAA, and BBBB are 223A through D. If you want to look.
In the same corresponding order. So you know what they are, Mr. Jackson, in order. Okay?
223.
223.
Thank you. My only other question, Your Honor, was regarding the parameters of closing argument. Last year, we were relegated to 1 hour. I would ask for an hour and a half.
Just let this pass.
They're asking for an hour and a half
No, I got it. But now you can go.
instead of an hour on closing arguments.
I would ask for an hour and a half for a final summation, given the gravity of the case, the length of the case, the amount of evidence that's been adduced. I think that's outrageous, and the court normally allows only an hour.
You might get an hour and 15 minutes out of me. Let me see about an hour. Let me see. You would not have got an hour and a half by asking for 2 hours. Mr. Brennan, what are you looking for? Do you want the same?
I don't have a position. I'll take whatever the defense is.
Let me think about it.
Yes,
All right.
Your Honor.
So we will see.
Thank you.
All right. So I'll see everybody at 10 o'clock tomorrow morning. Is there anything else we need to discuss?
No, thank you, Your
All
Honor.
right. We'll see you tomorrow morning.
All rise for the court, please.
Wow. Big sigh right at the end. I'm going to count that one as well.
Goodbye.
That brings us to 288. And Wow. Whoa. What a day. What a day. Defense has rested. The prosecution has no rebuttal. This is a strategic move because look at this. What Mr. Brennan basically had to do in order to get to pin Mr. Rentschler down to a statement was Mr. Brennan had to neuter his own expert, Mr. Welsher. Is that the name? Welsher and Rentschler, right? Crazy names. Had to basically neuter him to get to the premise to attack Dr. Rentschler's results. Now bringing in Dr. Welsher now, and knowing that the defense has brought in evidence the X-rays that he says didn't exist, it would just be more. And basically this goes to the jury, with the jury remembering the echoing words and the stinging, biting remarks that of the mic drops that Dr. Rentschler shared, and in the spanking he gave Mr. Brennan in the very last questioning. Now, closing arguments are going to be equal time. Mr. Brennan's going to go first. He's going to bifurcate it. He's going to go first. He's going to go last. He gets the same amount of time. In the middle, the defense goes, and the defense is going to have their way with it. It's going to be so spicy. Now, it's not happening tomorrow. That happens on Friday. So tomorrow we're going to get the charge conference. We're going to go through some of the slower parts. We're going to hear what the instructions are going to be to the jury as far as jury, these are the elements of the charges. This is what you need to find. If you find this, it means that. We're going to probably go over the jury instructions as far as the verdict forms go. That might be spicy as well. Remember, that was a heated object of debate, area of debate last trial as well, where, it may have even resulted in the mistrial because it was done poorly. Lots to go on. We might have a Friday the 13th verdict. Oh man, that's crazy. Closed caption doesn't work with how fast we bring you the court proceedings. We would have to delay it in order to do any further. All right, lots of things to do. We're going to portal over to get some legal analysis from Peter Tragos, who has been breaking this down, and does he's in the free Karen Reed camp. I can tell you that. But he has been breaking this down. Peter Tragos, the lawyer you know. His reactions are great. I enjoy seeing them. So let's see. The lawyer you know. If we can find him here, we'll portal over there. Where are you at, Peter? Where are you at? There you go. Boom. He's coming up at 4:25, so 5 minutes it's going to start. It'll give us time to do our outro and everything else. We'll bring you right over to him, and you can continue the conversation there. When you land, it would be great if you say hi to everybody there and click the like button. That's always the polite thing to do when we visit a guest channel. So that would be just awesome. We're going to portal to him. Thank Lizzie for the suggestion, and a few others asked that as well. Anything else to go over? Today was spicy. Like I said, they've just been turning up the spice meter throughout the trial. Tomorrow's going to be heated argument without the jury there, but heated argument, especially in a couple points. We might also hear the argument or the discussion about the maybe missing witness instruction. I think that might have been ruled on and just rejected on the surface. But we definitely get to hear the argument about the additional instruction about the evidence that was saved to the charge conference time, and we get to hear the argument about the charges themselves, the verdict forms, instructions to the jury, all that, and maybe a little bit about the time they get to spend on this. Can we get Mrs. Ari to give her thoughts? Yes, when she gets here. She's not right now. Peter is law daddy. He's got great hair. It was a great day in court. Thank you, everybody, for being here. It has been it's been amazing, and thanks to the mods, everybody else. I have ADHD. I've just had way too much hot chocolate. Thank you once again to Sergeant Ranch Lodge for the Stanley Cup. It's awesome. Kept it spicy and hot all day. Thank you all. It's been a wonderful time. You guys are amazing. The good news is we are near the end of this case. I think everybody, even those who are very invested in this case, are ready for this case to be over. It's run its course time-wise. We're ready to look at something else. We're ready to unblock those people who might have offended us earlier, patch up our acquaintances, and begin anew when the new case begins. But we'll be back tomorrow. Starts at 10 o'clock, but right now we're going to go over to Peter Tragos and catch what he has tonight, his take on the jury. I can't wait to hear the spiciness he has, or his take on the spiciness between Mr. Brennan and Mr. Rentschler. It was epic today. It was epic. It was epic. Desitin sold out. Sold out. You can't find it in the area. Yeah, I think Mr. Brennan took a complete spanking on that one. We'll see if he agrees. Tonight, when you go home, please hug the people you love, smile at someone, make their day just a little bit better. And please stay safe till we go live again tomorrow morning with charge conference and more arguments out of the Karen Reed trial. Thank you. You guys have a good night. We'll see you. Bye-bye.
It's bigger than you. It's bigger than me. It's bigger